I wanted us to look at how the law kind of came into being. And this is a pretty quick narrative, not, well, we'll hope it's quick, not necessarily completely authoritative. I mean, there is some speculation about how law came into being, but it sort of looks at what was the effect of the Silk Road and other places on uh, modern law. And so here are three people from ancient times, from essentially before Christ. And just to show you what a great PowerPoint presenter I am, I've built in some slide in issues. I guess I didn't do a good enough job and bring these pictures in later or put them in a perfectly good spot. But the first one is this guy here, the Code of Hammurabi. And what we have here is found in Babylon, I believe in the city state of Ur. Um, we have old bronze and or stone tablets, I believe they're stone, that are written on basaltic rock, which is essentially lava. Um, and they're actually a formation of almost statutes. It is a civil code. It includes things like if you steal, we cut off your left hand or your non dominant hand. You steal again, we cut off the other hand. So the sort of three strikes and you're out thinking that was prevalent in the 90s has its antecedents in Hammurabi. Um, we also, those of us raised in the Judeo Christian tradition, are acquainted with the two books out of the Pentateuch, the early um, Old Testament books, and these are law. Leviticus is lawgiver. And the tribe of Levi are the tribes of lawyers and judges and etc. But things like do not eat shellfish, do not eat cloven-hoofed animals. There's even some sexual stuff about when you can have sexual relationships with your mate. Those are just some examples, but these are actually written out rules that people were to live by. There's also, get my mouse going again, this gentleman right here, Confucia, better known to us in the West as Confucius, Confucia. Um, and he's interesting because around, I believe, and hopefully my numbers are right, around 2,500 years prior to Christ, he looked at what the ancients said and then taught it to a bunch of disciples. He didn't have many writings. He tended to be a guy who worked in the rice paddies. And anyway, uh, there are a number of adherents, and his is both a bit of law and some philosophy. But we can find, if you trace back, you'll see that some of the teachings of Confucia are in Deuteronomy and Leviticus, as well as in the Code of Hammurabi, which leads me to the supposition that a lot of modern mercantile law comes out of the ancient Silk Road, which was the great trading route between um, Mesopotamia and China. And it followed through the mountains into Afghanistan. Those were the great civilizations of the ancient world, centered in Baghdad and near Beijing or in Nanjing. Um, and the fellow we have here is Alexander. And we better know him as Alexander the Great, or as the Monty Python skit, A.T. Great. Um, and Alexander was a Macedonian who conquered most of the known world, conquered all of Mesopotamia, defeated Xerxes and the Persians, and made it all the way to the Ganges River in India before he turned back. A pretty disparate lifestyle or dissipated lifestyle. He had a pretty big drinking problem and also had a big womanizing problem. but his scribes found the Code of Hammurabi and brought it back to Greece. Now, this is important to us, the descendants of English law, because the Romans conquered the Greeks. And so, if you want to look at the great figures of antiquity, there's a book called Parallel Lives by Plutarch, a Greek who became part of the Roman court and wrote in both Greek and Latin the parallel lives of great leaders of Rome and Greece. And I think I mentioned in another lecture Solon, Solon, who many people consider the greatest statesman of all time. And he comes across that way without reservation. I can say this about him from reading Plutarch, if you believe Plutarch. Well, maybe let me back up one slide. What's important to us in the Roman law is that the Romans conquered all the way to Hadrian's Wall in Scotland. In fact, they built Hadrian's Wall to keep the Picts from coming in and disrupting the Pax Romana. And I know I've got this slide up for a long time, but I should illustrate if we get to you doing presentations, I kind of moved through it. I didn't have all the text up all the time. And notice that I don't have a lot of words up here. I'm trying to give you most of the information verbally, but I'm giving you enough visual cues that you can hopefully tag it. In Roman law, the Pax Romana ended most tribal warfare in Europe. Up until then, it was just shifting boundaries and taking one another and plundering constantly, et cetera, et cetera. So what we come to, though, around 410, it's probably earlier than that, the Roman Empire is conquered by the Visigoths and the other warring tribes, primarily Germanic tribes, and Rome no longer is the dominant nation, and that leads to what we commonly call the Dark Age. We go from the Enlightenment of Rome, which, yeah, it had problems, but if you look at using another Monty Python film, The Life of Brian, they come in and they're talking about, we need to have a revolution against the Romans. Well, what have the Romans ever done for us? Well, good roads. Well, other than good roads. Well, clean water. Well, other than clean waters. Well, courts and laws. Well, other than courts and laws and education and art. And, the list is really pretty good. There are people who like to detract from the British in the United States because of colonialism. But when we look at the alternatives, those countries really are fairly good. And, we're still benefiting from some of what the Greeks and the Romans gave to us. And I think we can make the argument that a lot of this really comes out of China and maybe even Afghanistan and India. It's a much bigger idea than that, the Queen gave it all to us. But when we get into England, so we see Arthur is a king, I believe, about the time the Romans disappear. And the Arthurian legends are around 415 to 480. I'm not real sure on those dates. And we see a number of small kind of tribal kingdoms, if you will, very similar to what we had in Germany and Italy, the sort of city-states. In Italy, after the fall of the Romans, we get to Milan as its own place. Siena is its own place. Venice is its own place. Milan is its own. Florence is its own. Rome is its own. And they are busy warring against each other. We bring back tribal warfare. Well, in England, we had essentially 5 major kings and then smaller baronies and whatever underneath that. But what was happening to the Britons was that the Danes, who also were in Norway at the time, were coming across the North Sea and invading. The records tend to show that they started up around York, which is fairly close to the Scottish border, and then they worked their way south. And what they would tend to do is they would charge gold to not come next year. So after a while, there's a fellow named Alfred, and this is the only British king who gets the Great added to it. So we have Albert the Great, or Alfred the Great, and Alexander the Great. I mean, Elizabeth is the longest reigning monarch, just past Victoria, I believe, sometime last year. Um, and what Alfred the Great does is he begins to rebuild kind of Roman law. And what he does, he got all the kings together and they fought the Danes. And they struck a deal with the Danes. And I believe you can see if you follow the succession of kings after Alfred, it's about 5 Danish kings in a row after him. The Danes had begun to stay. They'd also become part of England. Um, I'm corrected on this, but when I went to England, I certainly saw some really Danish looking people, blonde hair, blue eyes, very Aryan looking. Princess Diana Spencer may well have been Danish blood or something like that. But the big thing for lawyers and others, and civilization people, is this guy named the Venerable Bede. And I shouldn't say this guy. Bede was a high cleric. Now, I'm going to have to admit I'm weak on whether Christianity was the ruling thought at the time. I believe it was that Alfred and certainly Bede, but Bede was a cleric. What he created was something called the Domesday Book or the Doomsday Book. And if you go look at this is essentially land titles. So it shows who owns everything in all of England. And this way, when someone dies, we know who got it. We know who to go to get taxes. So this is approximately 940 years Anno Domini after the birth or after God's new dominion. The year of dominion, I believe, is how that translates, which means when Christ came in. And then we're going to take a little jump. We're going to go over all those Danish kings. We're going to go past William the Conqueror, who's a Frenchman, a Breton, who came in and claimed his family lineage to the British throne and defeated, I believe it's Edward the Confessor, but I blanked on this recently. And that's 1061 is the Battle of Hastings, and shortly after that, William the Conqueror is crowned head. And what the Domesday Book happened to do was it gave a real listing of who owned what. And so William could go in and say, okay, you either swear to me as king or we take your land. And he took a lot of the land away and gave it to Normans. And that's why you'll see all these Robin Hood books and everything else talking about those awful Normans, and much better to have pure Anglo-Saxon blood, which is 2 different tribes. So that's how pure that blood was. But what we get to is we eventually come on 1215 to the field of Runnymede, where the British have their great document signed, the Magna Carta. Let's see if it's getting us there. And the first link doesn't work, but the next link does. And I want you to look, let me see if I can get this a little bigger. I want you to look at the opening phrase here. John, by the grace of God, King of England, Lord of Ireland, Duke of Normandy. Okay, so we inherited the lands from William, and Aquitaine and Count of Anjou. Now, those claims to land in France lead to 100 Years' War and a whole bunch of other things. Henry V, if you're a real Anglophile, you can see a lot of stuff that's going on. But, Eleanor d'Aquitaine, who is the Lionel Winter's wife. The British that have always had a claim to large expanses of France, and they're willing to go war over it. But I think the interesting thing is that John is first to his archbishops, bishops, abbots. Now, so we've now named, here are the three hierarchies in the church. Now we get to the sub hierarchy of royals, earls, barons, justices, foresters. So, here we're beginning to get justices, foresters, sheriffs, stewards, sort of administrative agencies, if you will. And to all his loyal subjects, greeting. What this essentially does is it takes the power given to the king by virtue of, now divine right comes in later, but by virtue of birth, and gives that power over to the people. All right, compare this to the Constitution of the United States of America. We the people give to the government. We give to a federal government, and that's in our preamble. And when you look at the 10th Amendment, it basically says what we didn't give to the federal government and what we didn't give to the state government, we the people keep. That is, we're born with these inalienable rights, but in order to get good governance of one another, we're willing to give some power over to the government. Kind of a libertarian thinking. But that's where this sort of, that's why it's very popular still today. That's why that's why our country's revolutionary. So what we get to is, and the other thing the Constitution creates or that keeps is something called the common law. So if you'll bear with me, we're going to walk through a few things that we sort of have in common, that we inherited from the British, that we still sort of do the same way. First of all is the Star Chamber. Now, this is most famous in Henry VIII. And now I'm blanking on the Wolsey, I think, is the, wasn't his prime minister, but it was his chamberlain. And what would happen is if Henry VIII didn't like what you were doing, he would have Wolsey summon you to the Star Chamber. And this is a room in Wolsey's court at Hampton Court, which once Henry VIII decided Wolsey needed to be taken out, became Henry VIII's seat. Fabulous place. But you go in and it's stars up on the ceiling. I don't have a picture of that. I do in other slides. I didn't bring it in this time. It's worth looking up. Go look up Star Chamber. Essentially, if you were summoned to the Star Chamber, your next stop was the Tower of London. And some of the royals sent to the Tower of London, their next stop was the executioner's block, where their head was chopped off. You had no right of counsel. It was essentially confess, 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 very similar to the Spanish court of the Inquisition, except that you got nothing. We have something, you got no defense at all, and you didn't. You also had a limited defense in the court of the Inquisition. It was really j'accuse and it's over. But we have something slightly similar to this, and that is the grand jury. If you are indicted by a grand jury or brought before a grand jury, and they issue a true bill of indictment, before they do that, the defendant actually can be compelled to testify. Now, of course, under the Fifth and Sixth Amendments, has the right to be free from self-incrimination, and should assert that as under advice of counsel. I refuse to answer that question, but you don't have a lawyer that will sit in the room with you. Your lawyer can be outside, but you can't be in there while they're asking you questions. And they can definitely ask questions about where were you on that day, blah, 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 blah. You may be able to say, hey, I don't, but I'm not going to answer that, but that may lead to a bill of indictment. Local case that maybe is indicative of this is the Michael Brown shooting, where the jury came back no true bill against the police officer, Dennis Wilson. And Wilson did not testify under advice of counsel. He made it very plain, I'm not going to say anything about this event and so they didn't go after him. Um, but the British court did have what was called a circuit court. And this is where they would go from town to town to town. And just because I'm not real good at English geography, we're going to say that, let's say that the court starts in Cambridge and then goes over to Oxford and then comes back to a town outside of London. That would be a circuit that the court would ride. And the lawyers would all go, the clerks, all the attendants of court would go with them. And these are agents of the king. And this is something the Magna Carta kind of got going, is that the king would say, you don't just have to come before me. Here, I'm going to put court officials out, and you can go petition them for redress of grievances against one another, much limited redress against the king themselves. The problem we ran into is that the law tended to be very specific. You had to fit your facts, had to precisely fit the definition of things like trespass to property. And there wasn't a lot of law. Now, some people say, well, that's a good thing. We got too many laws now. And, a lot of us would agree with that. But what would happen was that you couldn't necessarily get a very balanced result. So what happened was the court of Chancellor of the Exchequer, that is the Treasury Department, for lack of a better term, would actually have its own court, and they would hear things based on the doctrine of equity, which is sort of what's fair. Now, one of the doctrines in equity is you cannot get equitable relief if you have dirty hands. If you've committed some fraud or some chicanery in this transaction, we're not going to hear your case. You've got to walk in here as a relative innocent. What we see in modern time is that the Court of Chancery was the place where couples could go and get what back then would have been sort of a divorce without really being a divorce, because divorce was illegal. We've slowly moved to the point where we've recognized that it may be best for everybody, for these people to just separate. Let's divide their property. Let's try to take care of the kids, all this sort of thing. And what we can see is that the principles of equity, the principles of balance, of interest, play best in that sort of family court system. And so I tell you that one of your best examples of modern chancery is in divorce courts. What we've seen since the 1950s is pretty much a merger of equity and law into one. We will still have lawyers who argue this is an equitable principle. We need to go into the thinking behind equity to make it work. And the courts are going to go, yeah, that makes sense, because, and we'll get to this in a second, it's kind of how we've always done it. It helps us to reason in the same fashion. Now, one of the things that the Magna Carta and then the Articles of Union after Cromwell, I got the wrong name for it, but anyway, when the king was returned to power, they passed a sort of quasi-constitution, but it's not really as strong as our Constitution. Our Constitution is potentially second only to that of Japan, and the Japanese Constitution was written by our army of occupation, and they're still governed by it. It's really kind of interesting that the Americans drafted the law for Japan. But what eventually happens is that most law now comes out of Parliament, all right? What the British have is a constitutional monarchy. The monarch is head of state primarily in name. Now, any decent prime minister or any ruling group realizes when they're in a sticky wicket, cricket term, it's best to get the Queen's approval. It was always better to have well, I'm really struggling. It must be late at night. Who's the great queen before Elizabeth? This is embarrassing. This will be public too. and I can't come up with her name. Anyway, it's always registered by the name. It's Victoria. I wanted to make it Violet for some reason, but it would be registered by the name of the monarch, Anne, who was the monarch around 1708. In the second year of the reign of Anne, is how they would talk about it. Now, the last thing I've got up here is the common law. And what this is the series of precedents. We've got certain facts. So what we look at, and we'll look at this more carefully, we generally have an event. From that event arise issues, EI. From those issues, we may say, we need a rule. We need some kind of law about this. So what the common law did was it would have the two competing lawyers propose rules to the court. Here's the outcome. And the court would then do an analysis, or the parties would go, here's why ours is the better of the two solutions that we propose. Or, the interesting thing in Britain and in America is we can actually propose things that appear to be on their face to be opposed to one another, but we have the freedom to do this because we walk in and say, Judge, we're not certain exactly what is right. We think this is better, but here's an alternative that's different from what we're talking about. Analyze it and see if you get a different result. Ordinarily we're going to try to get the same result, but we're going to try to shift the court's thinking. So what we've done over all the years in the United States, court opinions used to be short, and now they're pretty long. A lot of thinking, a lot of reasoning, a lot of let's go look at all the precedents, let's analyze them all, and ultimately come to a conclusion. And lower courts, so the Supreme Court of the state of Missouri makes a ruling that says gay marriage is permitted throughout the state of Missouri. Well, the only thing that can challenge that is the United States Supreme Court. Now, of course, the legislature can come back in and say, no, that's unconstitutional. You can't do that. It turns out the people of the state of Missouri voted for a constitutional prohibition of labeling the union of man and man, or woman and woman, or alternative lifestyle as a marriage. I haven't followed this and how it's moving up through the court. The United States Supreme Court essentially said, let's drop this barrier. I'm not sure. There are a lot of states that are sort of like Missouri where this may or may not come out. But ordinarily, a provision by the Missouri Supreme Court is final law absent alteration by the legislation and the governor. And so if the common law does something and the legislator says, that's terrible, maybe the common law decides we're going to restrict usage or possession of weapons. Well, our legislature may go, yeah, you can do that as to X, Y, and Z, but you cannot do that to A, B, and C type of weapon. We're going to pass a different law. Well, that would need to make its way up through the courts. And the purpose of precedent is that we can see the reasoning, we can see the why, we can see the wherefore, and we can see the projected outcomes. I believe I've got one more slide, and that is that what I'm looking at really is, in many ways, Great Britain, Italy. There are parts of Mesopotamia that are still governed by this. Some of China, but of course Australia, India is governed by a lot of British law, and so is Canada. So we've got maybe 40% of the world covered here, but we've left out most of the Napoleonic Code, which is the old French colonies. When Napoleon became emperor, he had his people write out their own code. It still prevails. We can still see large parts of it in the state of Louisiana, which was briefly a French possession because they took it from the Spanish. And then once Jefferson negotiated the deal with the French, we essentially bought out the Spaniards and the French simultaneously. There's also something called the German Civil Code. I don't know it very well. my colleague, Mike Costello, who used to do international law for Ralston Purina, um, says it is more of a prohibitory code. In order to do X, you must do Y. The United States and the British is a little bit like, if it's sort of reasonable, go ahead and try it if you think it's not going to hurt too many people. But be careful. If it does hurt people, we will come back and we will get after you. If it turns out that your analysis was not very good, we see this giant country up here, that's Russia. It's run almost like the old system under John. It's sort of at the Magna Carta phase of its legal development. Then, if we go into South America, we're still seeing a lot of colonial trouble, a lot of big challenges. Africa is very much all over the place. Some of the countries like Kenya and South Africa have British systems. They're relatively solid to do business with. Nigeria is the same, but it still has, it also, because of its proximity to some of the French colonies nearby, has some of the under the table stuff going on that we see a lot in South America and in the French colonies. Let me tell you a little story that my wife unearthed, and this is from there's a book called The Birth of Plenty, and it says that there are essentially four things that you need to have a solid economy. You need education, you need transportation, you need freedom of science, and we can look at either religions or governments repressing science. And the last thing you need is a fairly solid rule of law. And what we'll find down in South America is that the rule of law is despised, that it's all about under the table and payments. And we've always got that problem here in the United States that there's plenty of people who are worried about what's in it for me, and will take payments. But it used to be, and I think it may still be in Peru, in order to own land, you had to have 300 different government signatories. This essentially means you got to pay off 300 different people in order to get a deed. Well, you can imagine that there are just a few wealthy families that own everything. We're very lucky here in the United States that we actually have this free transfer of property, which we can trace back to Bede. It's an interesting enlightenment that we're the beneficiaries of. The last thing I've got up here, and was when I created these slides around 2007, 2008. Everything in the Wall Street Journal seemed to be pointing to the EU as the big coming. Everybody's going to be complying with the EU. Well, the EU has had all kinds of fiscal trouble, and this little kind of small, although this is what we're taught, or at least what I was taught, is the center of culture, is this sort of center of Europe, so where everything great comes from. Although we're beginning to see, wait a minute, a lot of this came out of China and made its way into Europe. And there are some enlightened greater thoughts coming as we encounter these things, but it's not like the Western people have a pure hold on anything. But one of the on civilization. But one of the things we may see a lot of in the EU is copyright information, trademark information. These are slowly becoming much and more global. Trademark right now in the United States can be a state by state affair. So we're going to talk a lot about all kinds of different things. I hope that this journey through the world, that does it make sense that part of our culture is actually Chinese, that it's Mesopotamian, that it's Roman, that it is the mixture of France coming in as the Romans conquered and as the Franks come up into England. And, when we look at modern American law, it's filled with terms in Latin and in French. And so, um, we're still dealing with some of the Roman law. The Napoleonic Code is a little more rigid. I like the flexibility of the common law that we're able to continuously argue. Well, that precedent was right at the time, but it doesn't fit now. Let's look at how we do things now. Let's move the law. And the law has some freedom to move there, but it's slow to do it, and for good reason. Thanks.